Senate President Escudero.
The Senate President is recognized to explain his vote.
Thank you, Mr. President. Distinguished colleagues, sa mga minamahal nating kababayan. For many of us, the past 2 weeks have proven to be an exasperating, mentally and emotionally exhausting experience. Both sides have fought bitterly a dialectical struggle to articulate what they respectively believe to be the correct position or view on the issues involved. Passions had run high as demonstrators, whether for or against impeachment, took to the streets armed with their familiar slogans and chants to air their voice on the matter. Various sectors of society, from business, retired military, academe, denominations of faith, offered suggestions for a return to a state of normalcy in the official relations of governmental branches. Through all these, and as early as the time when the Articles of Impeachment had been constituted, the court was specifically asked, told, urged, and argued to take no action of any kind and form with respect to the prosecution by the House of Representatives of the impeachment complaint. When the present petitions were knocking, so to speak, at the doorsteps of the court, the same clamor for non-interference was made through what are now arguments of lack of jurisdiction, non-justiciability, and judicial self-restraint, aimed at halting the court from any move that may have a bearing on the impeachment proceedings. The court did not heed the call to adopt a hands-off stance as far as the question of constitutionality of initiating the impeachment complaint is concerned. What lies in here, is an issue of genuine constitutional material which only the court can properly and competently address and adjudicate in accordance with clear-cut allocation of powers under our system. The claim, therefore, that the court, by judicially entangling itself with the process of impeachment, has effectively set up a regime of judicial supremacy is patently without basis in fact and in law, because it is not at all the business of the court to assert dominance, judicial dominance, over the other two great branches of government. Rather, the raison d'etre of the judiciary is to complement the discharge by the executive and legislative of their own powers to bring about ultimately the beneficent effects of having founded and ordered our society upon the rule of law. Mr. President, distinguished colleagues, the institution that is the Supreme Court, together with all other courts, has long held and been entrusted with the judicial power to resolve conflicting legal rights regardless of the personalities involved in their suits or actions. The court has dispensed justice over the course of time, unaffected by whomsoever stood to benefit or suffer therefrom, unafraid by whatever imputations or speculations could be made to it, so long as it rendered judgment according to the law and the facts. No one is above the law or the Constitution. This is a basic precept in any legal system which recognizes equality of all men before the law as essential to the law's moral authority and that of its agents to secure respect for and obedience to its commands. Perhaps there is no other government branch or instrumentality that is most zealous in protecting that principle of legal equality other than the Supreme Court, which has discerned in its meaning and ramifications through its application of numerous cases, especially the high-profile kind in the annals of jurisprudence. The Filipino nation and its democratic institutions have no doubt been put to a test once again by this impeachment case. Accordingly, the court resorted to no other than the Constitution in search for a solution to what many feared would ripen to a crisis in government. Sa muli, magandang gabi po sa ating lahat. Hindi ko po salita mga sinambit ko na ilang minuto. Yun po ay paraphrase at halos eksaktong quotation ng salita ni dating Justice Conchita Carpio Morales sa Francisco ruling na kinatigan ng mayoriya ng mga miyembro ng Korte Suprema, kabilang na si dating Chief Justice Puno, dating Justice Carpio, dating Justice Ascuna, dating Justice Panganiban. Ano nga ba itong Francisco ruling na pinag-uusapan natin ito? Ano nga ba ang pinagkapareho, pinagkaiba nito sa kasalukuyan nating hinaharap At bakit ko ba ito tinatanong? Ginoong Pangulo, bahagi ako ng Kongresong nagtangka na i-impeach si dating Chief Justice Davide. Bakit ko sinabing tangka? Dahil pinigilan po kami ng Korte Suprema. In-enjoin at nag-issue ng TRO ang Korte Suprema at ito yung desisyong yun. Francisco, case na palaging sinasite po natin. Ano bang pinagkapareho? Ang aligasyon laban sa nasasakdal noon na si Chief Justice Davide, kaugnay din ng corruption. Daang milyon din. Ang pinag-usapan, initiation of impeachment, na dapat sole prerogative din ng Kamara. Ang pinag-usapan, ano bang definisyon ng initiation na dapat sole jurisdiction din ng Kamara? Ang tanong ko po ay simple. Noong mga panahong yun, nasaan po lahat na nagrereklamo ngayon at nagko-question sa desisyon ng Korte Suprema? Yung mga mahistradong nagko-question ngayon na retirado na, bumoto sila pabor doon. Subalit ngayon, tila nag-iba ang posisyon. Ano nga ba ang pinagkaiba kung meron man? Klaro ang pinagkaiba. Iba ang pangalan ng nasasakdal. Today, Mr. President, distinguished colleagues, the very supremacy of the Supreme Court is being called into question, and with it, the very foundation of the rule of law. As Senate President and as a member of this chamber and as a member of the bar, I will not sit idly by and allow this. At stake is the very idea that justice should be governed by laws that apply to all, equally to all, rather than the whims and caprices of public opinion. As Justice Frankfurter once said, if one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Legal process is an essential part of democratic process. Whether it's a mob or a minority, bias and prejudice blinds, divides, and destroys. Former U.S. Supreme Court Justice Sandra Day O'Connor also said it best. The law provides necessary continuity amidst our constantly shifting political landscape. It guarantees everyone will be treated equally, whether they are in today's or yesterday's majority, so they know what to expect, whether what they do is popular or unpopular at that time. The courts, Mr. President, with the Supreme Court at the helm, are the guardians of the rule of law, making sure everyone plays by the same rules and receives equal justice. For the rule of law to prevail, the High Court must act as a compass, not as a political cheerleader, impartially applying the law by calling out violations, not swayed by public opinion or political allegiance. Respect for the rule of law, Mr. President, requires all of us to adhere to final or immediately executory decisions of the court, even when there is a winner and a loser, to avoid deadlocks and maintain legal order. Respect for the rule of law does not bar disagreeing with court decisions, nor from forming our own opinions on the meaning and intent and letter of the spirit of the Constitution. However, we must also have the humility to accept when we are wrong once the Supreme Court has already decided. Respecting the court only when you win or when it aligns with your belief is not respect for me. It is plain arrogance, or if at all, a power play. Cherry-picking court rulings destroys the judiciary's purpose. Disobeying the High Court's decision is a violation of the law, because under our Constitution, decisions of the Supreme Court form part of the law of the land. I made these remarks, Mr. President, amidst recent calls for this august body to disregard the Supreme Court's recent ruling in Duterte v. HOR. These calls for judicial disobedience have been aided and abetted by so-called legal luminaries and experts who fancy their wisdom and knowledge of the Constitution as better, higher, more supreme than that of the Supreme Court. Miyembro po ba sila ng Supremist Court? Miyembro po ba sila ng Super Supreme Court? Sa pagkakaalam ko po, iisa lamang ang Korte Suprema. At ayon sa ating konstitusyon, Korte Suprema ang bukod tanging pwedeng makapagsabi kung ano ang kahulugan ng ating saligang batas. Walang iba. Allow me to demonstrate, for example, Mr. President, the legal gymnastics these people have been undertaking. In the past, and I have borne the brunt of this, Sabi nila, forthwith ang sinabi sa Senado, ibig sabihin yan agad-agad. Despite the rulings of the Supreme Court that say it is within a reasonable time. Pero doon na tayo sa agad-agad. Sabi ng rules ng House, dapat i-refer ng SecGen immediately sa Speaker. 2 buwan bago niya ginawa yon. Oh, okay lang sa kanila. Di naman sila nagreklamo. Immediately po ang gamit ha. Hindi forthwith. Sabi naman ngayon ng Korte Suprema, immediately executory. Ay, teka lang. Hintayin muna natin. Hindi ba final? Kapag ka convenienteng gamitin yung mga salita pabor sa posisyon nila, edi okay lang. Kapag ka hindi naman, ay hindi rin. Hindi po ganun dapat yon. Hinihiling nila ngayon sa Senado na ipagpaliban muna ang anumang aksyon para intayin ang anumang desisyon ito kaugnay sa motion for reconsideration na inihain ng Kamara sa Korte Suprema. Subalit tulad ng naipaliwanag na kanina kaugnay ng motion na pinagbobotohan natin ngayon, kung magbago man ang Korte Suprema sa kanilang desisyon na unanimous noong July 25, 2025, meron pong paraan at proseso pa ang Senado para sundin ang bagong desisyon yan ng Korte Suprema kung sakasakaling mangyayari po yan. In the past, it was also said, nauna nagsalita si Senator Bato, bawal daw at walang karapatan mag-motion ang sinumang Senator Judge dahil trabaho daw ng depensa yon. Eh bakit yung mga parehong tao yung pinag-uusapan? Dapat maghain tayo ng motion for reconsideration. Hindi ba trabaho din ng prosecution yon? Hindi naman po pwede na pwede lang pag kayo, hindi na pwede pag iba. Now the prosecution has actually filed a motion for reconsideration, and rightfully so, and not by this chamber. Noon kapag nung bumoto kami para i-remand ang impeachment complaint sa Kamara, pinapaboran daw namin yung nasasakdal. Sinabi ko na rin yan, na yung kontra sa impeachment at pabor sa impeachment, hindi ko didinggin. Na yung kontra at pabor kay Vice President Sara Duterte, hindi ko didinggin. Dahil may rason kung bakit babaeng nakapiring ang mata ang simbolo ng ating hustisya, na humahawak ng espada sa kabilang kamay at panimbang sa kabilang kamay. Dahil wala po dapat kinikilala ang hustisya na personalidad. Sino man ang nasasakdal, dapat pareho lamang po ang ating mga magiging desisyon. Sabi din nila, will of the people daw ito. Eh sino ba si people? Balikan po natin ang naging desisyon ng Korte Suprema. Ayon sa desisyon ng Korte Suprema sa panunulat ni Justice Malcolm sa Alejandrino versus Manuel Quezon, pinag-aaralan po ito ng mga first-year law students. Quote, the judiciary under its powers to interpret the Constitution and the laws has the duty and the right to declare what the will of the people is as expressed in the fundamental law of the land. Hence, where the acts of the executive or legislative departments violate the will of the people as expressed in the organic law of the land, it is the sworn duty of the judiciary to interpret and to declare that will of the people and the right of the citizen has been violated and or transgressed. Allow me to answer a few more, Mr. President, Your Honor. As I stated earlier, sabi ng ilan, hintayin natin na maresolbahan ang motion for reconsideration. Pero dun sa parehong araw na naghain ng motion for reconsideration ng Kamara, nagsalita ang tagapagsalita ng Korte Suprema at sinabing immediately executory pa rin ang desisyon. Sinahit ko rin kanina ang Section 1, Rule 16, AM number 10-4-20 ng Supreme Court na nagsasabi na ang resolusyon ay magiging executory lamang kapag ka ito'y nagkaroon ng entry of judgment maliban na lang kung sinabi sa desisyon na ito'y immediately executory na siyang nangyari sa kasong ito. Binanggit din kanina ni Senator Cayetano ang Section 4, Rule 39 ng Rules of Court na nagsasabi na immediately executory na mga desisyon ay hindi kailangan maghintay na maresolbahan anumang apela o motion for reconsideration na nakabinbin. Ginagamit din ang operative fact doctrine. Ang operative fact doctrine po ay exception sa rule ng null and void ab initio. ito po ay hindi rule, ito ay exception sa rule. Gamit po ang sinulat na desisyon ni Justice Tony Carpio sa League of Cities versus Comelec. Ito ang sinabi po niya. The invocation of the operative fact doctrine is an admission that the law or act is unconstitutional. Bago po natin sabihin, gamitin natin to, aminin niyo muna, illegal at bawal ang ginawa ng Kamara. Sa parehong desisyon, sinabi din ni Justice Carpio, it will open the floodgates to wanton enactment of unconstitutional laws and the commission of unconstitutional acts and a mad rush for their immediate implementation before the court can declare them unconstitutional. This view, according to him, is an open invitation to serially violate the Constitution and be quick about it, lest the violation be stopped by the court. Sinabi din po ni Justice Carpio sa desisyong Aralio versus Aquino, those who acted in bad faith with gross negligence cannot invoke this doctrine. Hindi po pwedeng pakinabangan nung taong gumawa ng unconstitutional at illegal act ang doktrinang ito. Pwede lamang po itong gamitin ng mga partidong walang kinalaman dun sa ginawang mali, masama o di naaayon sa saligang batas. Ika nga, he who comes to equity must come with clean hands, and he who seeks equity must likewise do equity. Mr. President, distinguished colleagues, kinondina din ng ilang legal luminaries tulad ng Philconsa na dating pinangunahan ng nanguna sa impeachment complaint na si Speaker Romualdez, ilang taon lamang ang lumilipas, na hindi daw, bagong requirement daw ang due process. Dagdag daw ito. Mr. President, Your Honors, they should read Francisco again. They forgot that lack of due process in the impeachment process had been raised and in fact was specifically mentioned in the separate concurring opinions. And allow me to quote the concurring opinion of Justice Panganiban. The due process clause enshrined in our fundamental law is a condition sine qua non that cannot be ignored in any proceeding, administrative, judicial, or otherwise. It is deemed written into every law, rule, or contract, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charged official with number 1, notice, and number 2, opportunity to be heard prior to being impeached, are also unconstitutional. Needless to say, the due process limitation on the impeachment process was already discussed in Francisco. May pumalag ba nun? Wala. Yung nagre-reklamo ba ngayon kaugnay sa bagong requirement yung due process, nag-react nung sinulat ito at naging bahagi ng Francisco ruling? Hindi ko rin po napansin. Sinabi din po ng ilang legal luminary, partikular binanggit din ito ni Speaker Romualdez, when the court begins to create rules on how it and other high officials may be impeached, it risks writing the terms of its own immunity. This point was also discussed in Francisco. Ang sabi ng korte nito, illogical ito at non-sequitur. Alalahanin po natin. Hula lamang yung gagamitin din ito pabor sa kanila. Sa kaso ng Francisco, nakaupong Chief Justice ang nasasakdal. Pero sinabi mismo ng korte, hindi bali yan. Hindi namin pinapaboran ang kabaro namin sa pagbaba namin ng desisyong ito. Mr. President, the Constitution establishes a system of checks and balances, not a system of retribution. Threatening the Supreme Court with impeachment simply because one disagrees with the ruling is a dangerous assault on our constitutional order. The Senate, Mr. President, stands ready to uphold the integrity of the Constitution as well as the institutions created under it. My dear colleagues, we are told that to honor the court's ruling is to betray the truth, that by choosing fidelity to the law, we somehow abandon accountability, but nothing for me could be further from the truth. To disregard the ruling would not only defy the Constitution, it would drag the nation into a crisis it can ill afford. It would erode the authority of our laws, embolden those who believe they are above it because they know it all or simply know better. To those seeking to disregard the Supreme Court's decision, I ask these simple questions, Mr. President. Again, in light of the Francisco ruling on former Chief Justice Davide, and it was okay then because they did not want then Chief Justice Davide to be impeached. Are you truly for accountability or simply anti-Duterte? Do you truly respect and want to preserve the Constitution, or you simply hate the Vice President? Are you serving the nation's interest or protecting and pursuing your own personal ambitions or agenda? Are you fighting for truth, or are you simply after revenge? Do you really want a trial, or do you just want a conviction? Do you really believe that we are wrong, or do you simply think and feel entitled and believe that you are always right? Remove the name, Mr. President, of the Vice President in this case. Apply the decision of the High Court, as Senator Cayetano said earlier, to another impeachable official. Would your positions be the same? When I was faced with this situation, Mr. President, I respected the court's decision, even if I disagreed with it. I am still voting to respect that court's decision. As quoted at the start of my speech, Mr. President, the dispensation of justice over the course of time should be unaffected, whomsoever stood to benefit or suffer therefrom. The courts should be unafraid of whatever imputations or speculations could be made against it by those disagreeing. I will not cast a vote that says complying with the Supreme Court ruling is optional. Anyone who will say, I will respect the Supreme Court today and condemn it tomorrow, is not showing fidelity to the Constitution. It is submission to the passions of the day, to the shifting winds of public sentiment that may or may not be just. Fidelity to the Constitution, Mr. President, must prevail even when it is unpopular, inconvenient, or misunderstood. In fact, Mr. President, distinguished colleagues, it must prevail especially when it is unpopular, when it is inconvenient and misunderstood. Finally, Mr. President, let today's verdict be a stern and unequivocal warning to anyone who would dare use the Senate for their personal battering ram to further their personal political ambitions. To the House of Representatives, I say, do not allow yourselves to be used for the blind hatred and ambition of a few who did things haphazardly, gravely abused their discretion, and violated due process rights under the Constitution as found by the High Court itself. In spite of all these, you expect everyone to roll over in obedience. When we did not, you moved hell and high water to destroy personalities, malign reputations, and tarnish institutions. To these people, I say this: the Senate is not your playground to run after your political enemies. We are not an accomplice in any grand scheme. While others may be willing to play your game, I am not. I will never bow to a mob. I will never cower to the shrillest of voices. Let history, Mr. President, record that in this moment, we chose the Constitution. We chose the rule of law by defending the integrity of the Supreme Court and maintaining the system of checks and balances under our Republican system of government. Let this chamber be remembered, not for the passions we inflamed, but for the principles we upheld. I vote yes to the motion, Mr. President. I vote yes to the rule of law, yes to the Constitution, yes to the supremacy of the Supreme Court in interpreting it. Thank you, Mr. President.
Thank you, Senate President.